Hello, hello, it's me again, the snarky juror. I thought we were done for the day, but come to find out, the court still needed to go over the jury instructions. I guess it's called a charging session instructions. I'm calling it charging instructions. And it's only like a half hour long. So let's go ahead. We got to complete the record. So let me bring up some stuff. I got to put myself in the corner. And
so before we start, there's something I do want to talk to counsel about at sidebar.
of course, at sidebar. Of course. Okay, closed captions. Correct. So now I will admit I know very little about this. In Depth v. Heard, I saw them going over the instructions, and both sides have to agree on what's going to be spoken to the jury as to what they're supposed to pay attention to, not pay attention to, stuff along that line. Oh, did they call her up? Interesting. I've never seen her go up there. It's like moth to a flame. Now she looks familiar, and I don't remember why. Why does she look familiar? This isn't his wife, is it? No, this is somebody else. But she looks familiar. Okay, I'm confusing myself. Where am I? Okay, that's what I was. My mic's not on. I'm in the corner. I do not want to fast forward because I'm liable to miss something. Yeah, all the lawyers plus the defendant, or it's got to be in regards to a question or an instruction. It's got to be making sure that she has no objection. To be honest, I'm still in shock how quickly it ended. After all the crap Lolly put us through and how long it took to put us through it. It was like suddenly you're free. So me and the doggy went outside. I ate my macaroni salad, all servings of it, and have her food down so she can eat when she wants. She eats the soft dog food first. Then she checks to see if I'm eating anything. And she'll wait to eat the dry dog food until she's sure I don't have anything. Because I'm bad about giving her bites of my food. Okay.
You are unmuted.
All right. So the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft. But there's no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter? as a lesser included of the second-degree murder?
I'm sorry.
I'm sorry, I have no idea of my own. I must confer.
That's correct, Your Honor.
Okay. And neither side has requested an instruction of a lesser included of OUI,
It's correct as well.
and the defense is not requesting that?
That's correct, Your Honor.
Okay. All right. So,
I think OUI is our version of DUI. Driving under the influence.
all right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one. The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
Sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to work on it.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one too by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited. There,
I actually quoted it, Your Honor.
so from which one? From Haunch or?
From Hunch. Hunch quotes McCormick, and McCormick takes the law from Dusty. There are
Yeah, so
multiple cases that
Right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's
We prefer that.
all right. I haven't given that in years, but I'll give that part of it. And just to
Good.
finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right. All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes.
Okay, so I am going to put that in there. All right.
You could tell
And
it's the rank of the Commonwealth.
the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Do you want to just leave the whole generic sentence?
I think we can, yes. I think that's-
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's there's no evidence of drugs either. So do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but
I would prefer, Judge, just to keep it in with this number as
all right, so I will think about this one tonight, okay?
So they're going to have another sidebar tomorrow to say.
Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Ms. Giannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element? Yeah.
I'm sorry, Your Honor, is there a page number? I'm just going through my. 9. I have it, yes.
All right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion one I thought was from the model instructions. If I'm wrong, then we're fine with the model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read.
On page 5, the third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies.
Here's the thing. She didn't have that much up. She's the one that was operating the vehicle, and it was safely. There were no accidents between the bar and going over to 34 Fairview. She got turned around, but she'd never gone that way before. So I don't think that applies.
So we don't need both, Ms. Giannetti?
I agree, Your Honor.
So you had both, so I'm just not going to do that,
We're perfectly fine with that.
okay?
It keeps sounding like she's
Um,
saying Miss Yannetti. It's Mr.
So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless.
It wasn't wanton and reckless.
So for the fourth element, Ms. Giannetti, this is where your language.
Yeah, she keeps saying Miss Yannetti. She keeps forgetting to say the stir. Miss Stir.
You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
I
Mc?
see the language now, yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
Yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Giannetti. Okay? All right.
Mr.
I am going to give the lesser included offense of involuntary manslaughter.
I will be stunned.
So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those two sentences I find go better together, Ms. Giannetti. Is there any objection to that?
No, I understand.
Okay, any objection from the Commonwealth? So, Ms. Giannetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
so okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay.
Doesn't seem to be as critical of the Commonwealth's suggestion. Yes, I live on a busy street.
In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth. If you could consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Yannetti. Okay, then the lesser included offense, motor vehicle homicide, felony, OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence, and I do understand the law of lesser included sentence.
Okay.
Right, I get that.
All right. Thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident. So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, and they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror what failure to provide documentation of registration and things like that that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Giannetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 2 pages or 3 pages of definitions, so we won't do that.
Withdrawn.
Okay. All right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Your Honor, the request goes to the defendant's state of mind. Also, it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Giannetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay. All right. I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request. All right. So that's basically it. The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a conscience of guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt. There's an inference that the defendant deleted portions of the ring video, a narrow area of ring video videos that are missing. They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's. Then there's a period missing where the defendant shows the broken taillight to Jennifer McCabe and Kerry Roberts, and then the video resumes again when the victim's niece gets picked
Do
up.
not.
But not
let that
only
go.
the missing ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan Hospital due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dighton to Brockton is half a distance. Then they travel further all the way back to Canton to retrieve the murder weapon. Along with the defendant's brother, they all meet at the victim's residence to remove concealing evidence and intentional. There's also evidence of the defendant's statements going to her consciousness of guilt. Within hours after John's death, the victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay. The defendant says to her, "I only have to remember the bad times. You'll likely never hear from me again." Erin O'Keefe testified that she tells the defendant, "Of course we are, we're friends." She's never heard from the defendant since. So I think that goes to the defendant's state of mind in the hours after the death. But in addition to the ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
Ms. Giannetti?
Well, first of all, with regard to the ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to the defendant in the criminal case. With regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard, that part of the argument that the Commonwealth made.
I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. So I mean, to say that moving her car to her own home, where the police later found it because she was there and picked up the phone and said that the police were coming, and she stayed there and they were able to seize the car, that does not rise to the level of consciousness of guilt.
Okay.
Kind of the defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
Right. Well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then it makes sense for her to have her vehicle at her parents' house or her own house. Again, it does not rise to the level of consciousness of guilt.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost John. She quickly comes back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
Okay. It's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it.
I think it's
Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative.
it's a moot point.
Okay, Ms. Giannetti, I'll hear you on your instructions.
So I believe that we've covered the vast majority of it.
I'll give you the opportunity to argue the Bowden one, just so you can make a record.
Sure. All right, let me just pull up. Just have a moment here. I put that document away. That's the first thing.
I'll find your page.
Okay, so yeah, I mean, with regards to the Bowden evidence or instruction, Your Honor, having done this for as long as I have, it's requested a lot and not given, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this in closing argument.
Right.
But I think that if there's any case where a Bowden instruction should be given, it's this one. We start with the conflict of interest that existed at the start of this case, and the fact that Michael Proctor was allowed to not only continue with the case, but to be the lead investigator or police officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that he never, as a lead investigator, went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's arm. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, John McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, evidence, the way it was handled, or I should say mishandled. Starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, but not being properly handled, and the fact that there are no chain of custody logs for the evidence before March of 2022. So I just highlight those, Your Honor, as examples. I believe there's more, but that's the record that I would make.
Okay, so you satisfied you've made a complete record on this?
I do. I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay, so nothing else?
I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or
Yeah.
not.
Thank you for bringing that up, Ms.
I
McLaughlin.
agree that it's not appropriate.
Okay. All right. So I will see you tomorrow morning.
Question already, and I haven't tried this court before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
Permit the use of chalks for closing argument?
So can we focus on this? So does the defense intend to use chalks?
I'm going to defer to my co-counsel on that.
2
What do you intend to use?
photographs of the vehicle and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in evidence, photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it for me.
Okay. Commonwealth have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any,
The request is I'd like to see that.
sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They
Okay.
may not remember what that is.
No, I have
No,
absolutely.
they may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right. They may not know that. Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
All right. Why did you want to move them into? We'll talk about this.
Okay.
All right.
When is that done?
At the
At what point?
at the end of the instruction, before I give the instruction on be fair, the SJC instruction on be fair.
Can I ask a question?
Yes.
Do you pick a 4th person?
Yes. Yeah.
So sometimes it's done by lottery. I just wanted to.
No, so, right. In Massachusetts, it's supposed to be chosen by the judge.
I've seen it
So
both ways. Thank
I
you.
know. All right. Anything
I
else?
need to learn more about Massachusetts law.
Yeah. All right. Thank you. We'll see you tomorrow. Jim.
Court will rise.
Okay. There's that. If I find anything else, I'll go to it. What am I trying to do? I'm trying to get out of here before. No, that's not how you get out of it.
This is an innocent woman. She didn't do it.
It's a controversial case that's divided a community.
Karen Reed is accused of murdering her police officer boyfriend.
Prosecutors say she ran him over on purpose and left him to die in the cold.
But Reed claims that she's being framed.
It smells suspicious.
After years of legal fireworks,
I couldn't get it to stop. I couldn't find the right button to push. Me and buttons don't get along at all. At all. Okay. Well, that's it until tomorrow, I guess. I thought I was done half an hour ago, but I was wrong. Okay, we'll leave it at that. This will be the, how did they put it? Charge conference. I guess it's charge as into what they're charging the jury to do, how they're to look at certain things. So that's my understanding. So again, enjoy the rest of your day. Brain went away again. It does that a lot. So we'll see you tomorrow for jury instructions, closing arguments, jury instructions, and everything being handed over to the jury. And the impression I'm getting is most people in the legal field don't think they're going to be deliberating for very long. And I tend to agree, even though I'm not in that group. So we will check in again with you tomorrow. So until tomorrow, take care and God bless.